Welcome, everyone. We are live with a new episode of Level Up Law, where every Tuesday at noon, South Carolina Legal Services levels up your legal knowledge about an area of law that we practice in. And we are delighted to bring you today's episode on getting removed from the sex offender registry. I'm Susan Engel, Senior Staff Attorney and the host of Level Up Law. And as always, our producer, Kenneth Elliott, is from our IT department. He's in the background making sure everything's running properly today. You are viewing live our employment law unit head here at South Carolina Legal Services. It's Stephanie Vanderhorst from our Charleston office. Stephanie is going to be explaining for us how to apply to get your name removed from the sex offender registry in South Carolina. And she has done this and been successful at it, so she knows what she's talking about. But before we turn it over to Stephanie, we do always want to remind you that this is not legal advice. It's just general information for the public, but it is important information, so we want everybody to be aware that this is possible and how it can be done. But if you do need the help of a lawyer for this or anything else, just call our intake line here at South Carolina Legal Services or apply online, and we'll give you that information at the end of today's presentation. Also, as a reminder, all of our episodes are posted by our producer, Kenneth Elliott, to the Level Up Law playlist on our YouTube channel, usually within about 24 hours. Stephanie can answer general questions today if there's time at the conclusion of her presentation. So just put any questions that you have in that question box. So without any further ado, I'm going to turn it over to you, Stephanie. Welcome back to Level Up Law.
Thanks, Susie. I hope everyone's doing well this afternoon. It is now this afternoon on this Tuesday. Like Susie said, I am the Employment Law Unit Head for South Carolina Legal Services, and today we'll be talking about a relatively new opportunity here in South Carolina, which is to have your name removed from the sex offender registry. And so we're going to start out with some basic information about the sex offender registry and then move on to the removal process. So what is the sex offender registry? It's a list of convicted sex offenders in a state. To be a sex offender, you have to be convicted of a crime that is defined as a sex crime under our criminal code. It can be searched within a state. So we have a search through the South Carolina Law Enforcement Division's website. You can search for sex offenders, registered sex offenders. And it also can be searched through a national database called the National Sex Offender Public Website. So the registry includes the offender's address, physical appearance, and criminal history in South Carolina. It also includes a picture. In fact, here locally, we have a newspaper that will print at the beginning of the month, the list of registered sex offenders here in Charleston County with a picture. You can be labeled a sex offender and be required to register as a sex offender in South Carolina for crimes ranging from indecent exposure to criminal sexual conduct with minors. Now, indecent exposure can be somebody who was convicted of, relieving themselves in public. So the crimes, there's a large breadth of crimes that are included. So if you are convicted of a sex crime, you are required to register with the sheriff in the county in which you live on a biannual basis, at least a biannual basis. And that that registration comes with fees as well. Now, becoming a registered sex offender also has some collateral consequences. It's very difficult to find a job. It is difficult to obtain housing. There are restrictions on where sex offenders can live. It can be very, very difficult once you are released from jail or prison to then restart your life if you are on the sex offender registry. So Prior to 2021, individuals convicted of sex crimes in South Carolina were required to register as a sex offender for life. Whether you were convicted of criminal sexual conduct with minors, or whether you were convicted of indecent exposure because you decided to relieve yourself and pee in public or something of that nature. It also includes crimes of like voyeurism, peeping, things like that. In 2021, the South Carolina Supreme Court established in Powell v. Keel that South Carolina's lifetime registration requirement was unconstitutional because it did not provide for a process of judicial review to determine if the sex offender was at risk of reoffending. So in that case, the Supreme Court basically gave the legislature a year to establish a process for judicial review and removal from the registry. Almost, as far as I know, almost all other states have a process for removal. At that point in time, we were the most stringent. We had the most stringent laws for sex offenders in South Carolina for registry. So the process for removal, it starts pretty much with an administrative process. Well, it depends on what tier you're in. So sex offenders are classified under a 3-tiered system: tier 1, tier 2, tier 3. And each tier has their own removal process. Tier 1 and tier 2 are basically the same. The crimes are different, but the removal process is the same. And then tier 3, which is the most severe, for the most severe offenders, has the most difficult removal process. Okay. So for tier 1 offenders, those offenses include, this is not an exclusive list, so they include indecent exposure, incest, peeping, voyeurism, aggravated voyeurism, sexual intercourse with a patient or trainee. So like if you were, the most readily available example in my head is if you were a prison guard or a guard at the jail and you engaged in sexual intercourse with an inmate, that would fall under that category. So tier 1 offenders are permitted to apply for removal after you have been registered for 15 years. As long as you have not been convicted of failure to register as a sex offender in the last 10 years, you have not been convicted of any additional sexual offense after being placed on the registry. So if you're convicted of a crime, it's a sex crime, and you're required to register, and you do register, and you continue to register for a period of 15 years, at that 15-year mark, you can then apply to be removed from the registry. In order to do that, you have to submit the following items to SLED, which is the South Carolina Law Enforcement Division. It's our state law enforcement agency. They have an application available on their website that you fill out. It's just a form, has your basic information in it. You have to get fingerprinted, 2 sets of fingerprints. You can request fingerprint cards from SLED. Sometimes they have them at your local county sheriff's office. The filing fee for the application is $250. And then you have to provide proof that you completed successfully all sex offender treatment programs that you were ordered to complete as a requirement of your sentence. Now, if you weren't ordered to complete any sex offender treatment programs, then you don't have to provide any proof. But if you were ordered to complete those programs, then you're going to need those original certificates of completion, which are provided at when you finish the course. Okay, So tier 2 offenders, it's basically the same process, just a little tweak. Those offenses include trafficking in persons, criminal sexual conduct in the second degree, criminal sexual conduct with minors second and third degree. Tier 2 offenders are permitted to apply for removal once the offender has registered for a total of 25 years, as long as the offender has not been convicted of failure to register or convicted of an additional sexual offense after being placed on the registry. The application requirements for tier 2 offenders are the same as tier 1. You need to complete the SLED application that's available on their website, which is provided later in the presentation. You will need to provide 2 sets of fingerprints, a $250 filing fee, and then proof that the applicant successfully completed all sex offender treatment programs that were required. So for tier 1 and tier 2 offenders, once SLED receives the required documents for a completed application, SLED will review the documentation provided and notify the original prosecuting agency for approval. So generally, that's the solicitor's office in the county where the offender was convicted. Once that documentation has been verified by SLED, SLED shall, so SLED is required to remove an offender's name from the registry and notify that offender that the offender is no longer required to comply with the registry requirement. And SLED has 120 days to do this. And I will say that SLED uses every single one of its 120 days, in case you're wondering, or if you're waiting. Now, if the offender has been convicted of any prohibiting offenses during the applicable period, during the 15 or 25-year period, has failed to substantially comply with the statute regarding removal. So you didn't follow the directions when you were submitting your application, or an objection is filed by the original prosecuting agency, that's the solicitor's office, generally, in the county in which you were convicted. SLED shall not remove the offender from the registry and shall notify the offender that the offender has not been relieved of the requirement to register as a sex offender in South Carolina. So, if one of these 3 things is met, so if the original prosecuting agency files an objection, if you've been convicted of a prohibiting offense during the waiting period, the 15 or 25-year waiting period, or if you fail to substantially comply with the application requirements and SLED denies your application for removal, you do have the opportunity to appeal that determination. The appeal is not done through SLED, so you cannot administratively appeal the decision. You have to file a motion in General Sessions Court pursuant to Section 23(3)(463). So once you get that denial, you file the motion in General Sessions Court in the county in which you were convicted, or if the conviction occurred out of state, in the county in which you lived. The state of South Carolina must be named as a party. SLED should not be named. They are no longer involved. And then the court must make a determination upon a finding of clear and convincing evidence that the offender is no longer a foreseeable risk to reoffend, and that it is in the best interest of justice to grant the motion for removal from requirement of registration. An individual appealing SLED's determination is entitled to the assistance of counsel, and if that person is indigent, So if the person basically qualifies for our services here at Legal Services, the court must appoint counsel to assist the person. Similar to the requirement, or basically it is the requirement of a public defender if you're unable to afford counsel in a criminal proceeding. Now, SLED has to provide an affidavit and the reason why the request for removal was denied. And the court may also request that the offender be examined by a qualified examiner to determine whether or not the offender is at risk for reoffending. So once this is filed, there's a hearing. Each side puts up their case, and the court will issue an order either granting removal or denying removal in that particular case. So for tier 3 offenders, the process is different. These are the crimes that tier 3 offenders have been convicted of crimes that South Carolina has determined to be the most egregious. And so those include criminal sexual conduct in the first degree, criminal sexual conduct with minors in the first degree. This is not an exhaustive list. There are many others. So for tier 3 offenders, there's no process for administrative removal, and they're going to have to petition General Sessions Court, which is the criminal court. So they may file a motion with General Sessions to request an order for removal after 30 years from the date of discharge from incarceration without supervision. So after they are released, if they are not required to be supervised, they can wait 30 years and then file that motion in General Sessions Court. Or if they are required to be supervised after release from incarceration, that they can apply 30 years from the termination of active supervision of probation, parole, or any other alternative to incarceration. So it could possibly be longer than 30 years from your conviction. Well, it is longer than 30 years from your conviction. It's 30 years from your release from incarceration or supervision. So the motion has to be filed in the county where the original conviction occurred, or in the county in which the offender resides if the conviction occurred out of state. Again, this is similar. This is the process basically for the appeal from a denial by SLED. So the state of South Carolina must be named as a party. SLED should not be named. And then, of course, the court must hear evidence and make a determination upon a finding by clear and convincing evidence that the offender is no longer a foreseeable risk to reoffend, and that it is in the best interest of justice to grant the motion for removal from requirement of registration. Again, an individual requesting a hearing under this section is entitled to the assistance of counsel, and if indigent, the court must appoint counsel to assist the person. So for tier 3 offenders, the waiting period between conviction and the time that you can apply for removal is quite long, more than 30 years most likely. And it's also more difficult because you have to file those motions in General Sessions Court, which can be done pro se, but is most likely going to require the assistance of an attorney in the first place, as opposed to the administrative process through SLED. Now, if the applicant is denied through the administrative process through SLED or by the court, you must wait 5 years from the denial in order to reapply. So for tier 1 offenders, if you're denied the first time after 15 years, it could be 20 before before you're removed, or it could be longer if you're denied a second time as well. Now, SLED provides pretty detailed information about the sex offender registry removal process on their website, which is located at www.sled.sc.gov. The application is available on their website, along with very detailed information or white papers about each tier and the process and what those sex crimes are that are defined under each tier. So, as you may know, or you may not know, April is Second Chances Month. Every year in April, South Carolina Legal Services tries to provide content and information about removing barriers to employment. In the past, prior to this process being available, we have done level up law programs on expungements and pardons, driver's license reinstatements, child support reductions, because that can affect your driver's license as well. So we're happy to provide some information on this new process. As Susie stated at the beginning of the program, I have been through this process with a client and been successful. It is rather pain-free. There's no hearing. You're not required to appear in front of a panel like you are in a pardon situation. So I would encourage you to apply if you meet the standard. I have not had to appeal at this point, so I don't have any general information on that. So, as Susie said, I'm happy to take questions at this point. And then, of course, on our screen right now is our contact information and how to apply, as well as our resources that we have for the general public. And you should definitely check us out on Instagram and Twitter and our YouTube channel for all other Level Up Law episodes. Okay,
Well,
Susie, I think that's all I got.
yeah, here's a question. What are some types of things that will show that you're not a foreseeable risk to reoffend and it's in the best interest and so forth?
Yeah, so if you haven't had any interaction with law enforcement in those 15, 20 years,
Mhm.
if you have registered as you're supposed to under the law during that time, in the initial case, basically the plaintiff presented evaluations from mental health experts stating that he was not a risk to the public and he was not a foreseeable risk to reoffend. So, statements from a mental health professional, evaluations from experts in the field, the fact that you've had no interaction with law enforcement over that period, that waiting period that you were required to register, the fact that you complied with all rules and regulations regarding sex offenders, all of those things work in your favor.
Okay. And I assume that having been a good citizen, otherwise having a job and, those kind of things.
Yeah, of course. Yeah, those things always happen. I will say this, that my experience is that if you're required to register as a sex offender, it's really, really difficult for you to maintain stable employment and stable housing. So what I see a lot is just a lot of different employers over that period of time, because what ends up happening is somebody becomes aware that you're required to register as a sex offender. They make a complaint to the employer, and the employer, just in abundance of caution, terminates that employment.
Yeah, that makes sense.
Yeah.
I do think there do seem to be a lot of organizations, one of which we'll talk to next week on Level Up Law, who are trying to work with people to, find those job opportunities. And I'm sure that helps when you can, find it and, manage to hang in there with it. Very interesting. And, this was really great to know about. And thank you for, going through it so clearly to kind of see what makes you eligible and the different tiers and all that. And this was a law that I didn't really know about. So always glad that our awesome attorneys at South Carolina Legal Services are bringing new information for folks out there when they join us on Level Up Law. And this was, as you said, great way to start off our observance of Second Chances Month. So I really want to thank you, Stephanie, for doing this for us today. It was a terrific presentation. And then, of course, thank our audience, both live and on the replay. We hope the information is helpful to you. And, definitely if you're watching this on the replay on our YouTube channel, where producer Kenneth will upload it very soon, definitely share it out. And while you're there, if you haven't subscribed to our YouTube channel, by the way, definitely do that. We're approaching 3,000 subscribers on our YouTube channel, so we're really excited about that. All the good information that is getting out there to the public, like what Stephanie has presented today. So I really do appreciate it, Stephanie. It doesn't
Thanks
look
for
like
having me, Susie.
Oh, you're welcome. Anytime. It doesn't look like there are any other questions. So just want to remind our viewers, Stephanie has all of our information there for our social media and our websites. So I really do encourage everyone to check that out and follow us, because we're always putting up great information and resources for you out there. And then I want to be sure to have you join us next week for a live episode of Level Up Law, where Jerry Blassingame of Soteria CDC will join us as we continue this observance of Second Chances Month. The folks at Soteria have a mission to assist people and their families who have been impacted by the criminal justice system, just like Stephanie's been talking about here, and other things as well when they're reentering after being incarcerated. Transitional housing, life skills, job training, and that sort of thing is what they do. And there's other, I know, organizations like them, but Soteria has been a great one here in the upstate where I'm located. And so we're delighted that Jay Blassingame is going to be joining us on Level Up Law next week. So definitely tune in to hear what they're doing and some of the ways that they are helping folks in the community. So again, thanks, Stephanie. Great presentation. Thanks to our audience for tuning in today on Level Up Law. And that concludes today's webinar. Thanks, everybody.